Hi everyone, welcome back. Today we are going to discuss about reference of industrial dispute. That is reference under section 10. Now, the object of Industrial Dispute Act is to make reference of industrial dispute before the proper authorities. Section 10 of the Industrial Dispute Act in the operative section of the Industrial Dispute Act. By this, the appropriate government is competent to refer any industrial dispute before the competent authorities. A precondition for making a reference under this section is the existence or apprehension of an industrial dispute. A constitution bench of the Supreme Court in United Commercial Bank case, that is a 1952 case, observed that the government should indicate the nature of the dispute in order of reference. The order of reference is an administrative act and it is discretionary in nature. However, this discretion must not be exercised in an arbitrary manner. Now, to whom the reference is made? Under section 10, the appropriate government can refer the dispute to any of the following authorities, that is, the board or court of inquiry or labor court or tribunal. If the appropriate government is the central government and the dispute involves any question of national importance, it can refer the dispute to national tribunal. Now, elements under section 10. Section 10 mentions the following points. 1. The government should satisfy itself whether any industrial dispute exists or is apprehended. 2. It is discretionary. 3. It will be referred to the body specified under section 10. 4. It is an administrative act. So these are the elements under section 10. Before making a reference, there must be some materials which will show the existence of a dispute or its apprehension. Ordinarily and generally, in a large number of cases, reference is made when the government finds that an industrial dispute exists. In Imperial Hotel New Delhi versus Chief Commissioner Delhi. Imperial Hotel New Delhi versus Chief Commissioner Delhi, 1959. A dispute between the Imperial Hotel New Delhi and its workmen, represented by the Hotel Workers Union, was referred to adjudication under section 10. The Supreme Court held that section 36 permits workmen to be presented by the trade union and further held that it was not necessary to mention who were the workmen involved in the dispute. So that was held in Imperial Hotel New Delhi versus Chief Commissioner Delhi, 1959. Government cannot be compelled to make reference. It is clear from the language of section 10 that the government is not bound to refer the industrial dispute. Being an administrative act, a writ of mandamus will not lie against the government. Reference can be withdrawn, cancelled or superseded. Making reference under section 10 is purely discretionary. That is, government neither may or may not refer the dispute. In State of Bihar versus Ganguly, that is 1958. State of Bihar versus Ganguly, 1958. Gajendra Gadkar Justice held that an order of reference once made cannot be withdrawn, cancelled or superseded. Reference can be amended or corrected. So in State of Bihar versus Ganguly, 1958, Gajendra Gadkar Justice held that an order of reference once made cannot be withdrawn, cancelled or superseded. Reference can be amended or corrected. So this is an important case law with respect to reference of industrial dispute. State of Bihar versus Ganguly, 1958. In South Indian Labour Relations Organisation versus State of Madras, 1954, that is South Indian Labour Relations Organisations versus State of Madras, 1954, the Supreme Court held that it is open to the government to amend or correct an order of reference. Thus, government can add a matter connected with the order of reference or any clerical mistake or accidental slip or omission. And in Dabur Limited versus their workman, 1970. Dabur Limited versus their workman, 1970. The government of Bihar had made reference to the labor court partner. The correct labor court was Ranchi, and it was corrected to that extent. Such a clerical error can always be corrected, and such a correction does not amount to either to withdrawal of reference or cancellation of reference. So that was held in Dabur Limited versus their workman, 1970. In Punjab National Bank versus Manjeet Singh, 2006, Supreme Court held that individual workmen cannot be made a party to a reference in an industrial dispute having all India implication. So that was held in Punjab National Bank versus Manjeet Singh, 2006. Now going further, time factor of reference. Section 10 never specifies the time within which the government has to make the reference. So, Section 10 never specifies the time within which the government has to make the reference. The words "at any time" indicate the intention of the legislature that the government has the discretion to refer the matter. In Sadhuram versus Delhi Transportation Corporation, 1983, Sadhuram versus Delhi Transport Corporation, 1983, the conciliation officer had reported to the government the fact of failure of conciliation proceeding. On this report, the government referred to the dispute to the Labour Court. The Supreme Court held that the government was justified in thinking that there was an industrial dispute, and therefore the reference to the Labour Court was within its power. In Workman of Jant P. Goats Limited versus State, Workman of Jant P. Goats Limited versus State, 1975. Here it was held that the state government acted illegally in refusing to refer the matter for adjudication. Now, in Sri Krishna Jute Mills versus Government of AP, Sri Krishna Jute Mills versus Government of AP, 1960. The appropriate government can reconsider its earlier decision not to refer a dispute and order fresh reference. So that was held in Sri Krishna Jute Mills versus Government of AP, 1960. In Engineering's Staff Union versus the State of Bombay, 1960. In Engineering's Staff Union versus the State of Bombay, 1960, the court held that partial reference is proper and the government is not bound to refer all the aspects of the industrial dispute. So, if one thing, it is discretionary for the government to refer, and the government is not bound to refer all the aspects of the industrial dispute. Further, principles governing scope of reference under Section 10. The Supreme Court considered the scope of reference under Section 10 in many cases, and the following important principles can be deducted. The first one, Section 10 applies to minority educational institutions protected under Article 30, Subclause 1 of the Constitution, and this was held in Hospital Employees versus Christian Medical College, 1988. Once again, Section 10 applies to minority education institutions protected under Article 30, Subclause 1 of the Indian Constitution, and it was held in Hospital Employees versus Christian Medical College, 1988. Now, the second principle, in Darsak Limited versus VIT, that is 1986. Darsak Limited versus VIT, 1986. In Darsak Limited versus VIT, 1986, the court held that the workmen's demand that office bearers of their union should not be transferred to another branch during their term can form the subject matter of an industrial dispute. Now, the third principle, that is Chellappan Pillai versus Union of India, 1986. Here, the court observed that the application of a reference filed by only one party is not maintainable. So, once again, in Chellappan Pillai versus Union of India, 1986, the court observed that the application for a reference filed by only one party is not maintainable. Now, the fourth principle, the power of reference is purely discretionary in nature. The court in Showalis and Company versus State of Tamil Nadu, Showalis and Company versus State of Tamil Nadu, 1988, held that the government may refuse to make reference of the dispute on the following grounds, that is, A. If the claim is very stable, B. Opposed to the provisions of the Act, C. Inconsistent with any agreement, D. Patently frivolous, E. Likely to have an adverse effect as general relations between the employer and employees in the region. So these are the 5 factors that was discussed in Chauvalis and Company versus State of Tamil Nadu, and these were the 4 principles that was derived from the various case laws. So that is, section 10 is applied to minority education institutions that was held that institutions protected under article 30 subclause 1 of the Indian Constitution, and that was held in Hospital Employees versus Christian Medical College. And the second principle, that is in Dasak Limited versus VIT, the court held that the workmen's demand that the office bearers of their union should not be transferred to another branch during their term can form the subject matter of an industrial adjudication. The third principle, in Chelapan Pillai versus Union of India, the court had observed that the application for a reference filed by only one party is not maintainable. And the fourth principle is what we discussed under Chauvalis and Company versus State of Tamil Nadu. And here 5 factors or 5 grounds were discussed based on which the government may refuse to make reference of the dispute on the following grounds. Further, in Workman versus Government of Tamil Nadu 1988, it was held when there is it is likely to have an adverse effect as general relation between the employer and employees in the region, the government may refuse to make reference of the dispute to the appropriate tribunal or the labor court, and that was held in Walkman versus Government of Tamil Nadu 1988. In Goodyear India Limited versus Industrial Tribunal 1969, the court pointed out that even when there had been an earlier refusal, a fresh reference is possible. So once again, in Goodyear India Limited versus Industrial Tribunal 1969, the court pointed out that even when there had been an earlier refusal, a fresh reference is possible. And state government's ground for refusal, can it be questioned? This was discussed in Veerarajan versus Government of Tamil Nadu 1987. So in Veerarajan versus Government of Tamil Nadu 1987, it was discussed whether the state government's ground for refusal can be questioned. The Supreme Court observed, in a dispute arising out of termination of service of workman, the government cannot refuse to make reference on the basis of its opinion that the domestic inquiry was in conformity with the principles of natural justice, and that the punishment of termination of service was proportionate to the gravity of the offence. Therefore, the state of Tamil Nadu should have made a direction to refer the dispute for adjudication. So once again, in Veerarajan versus Government of Tamil Nadu, the question was the state government's ground for refusal, can it be questioned? And here the ground for refusal by the state government was, by the opinion of the state government, the domestic inquiry was in conformity and it was according to the natural principles of the justice principle, and that the punishment of termination of service was proportion to the gravity of offence. So these were the 2 grounds that was held by the state government, that the domestic inquiry was in conformity with natural justice principle and the punishment was in proportion to the gravity of the offence. So the question that arose here was, can this grounds of refusal by the state government be questioned? That was in Veerarajan versus Government of Tamil Nadu. And here the Supreme Court held that it is the government cannot refuse to make reference based on these grounds, and the state of Tamil Nadu should have made a direction to refer the dispute for adjudication. So this is a very important case law with respect to reference for adjudication, that is Veerarajan versus Government of Tamil Nadu. Now we have voluntary reference, that is section 10A. Voluntary reference is discussed under section 10A. So section 10 capital A of the Act deals with the voluntary reference to arbitration. This section was introduced in 1950. For invoking section 10A, the following conditions must be fulfilled, and 4 conditions are given. The first one, there must be an agreement. Second, it should be in writing and signed by the parties. Third, it must relate to an industrial dispute existing or apprehended. Fourth, an arbitrator under Section 10A is not a tribunal within the meaning of the Article 136 of Indian Constitution. So these are the 4 conditions that must be fulfilled for voluntary reference that is discussed under Section 10 capital A. An arbitration agreement is necessary for the application of Section 10 capital A. Such agreement shall be signed by the parties thereto. A copy of such agreement shall be forwarded to the appropriate government and the conciliation officer. The appropriate government, within 1 month from the date of receipt of such copy, shall publish it in official gazette. If the appropriate government is satisfied that the persons making the reference represent the majority, then it shall issue a notification. Any party other than the parties concerned in the dispute shall also be given an opportunity of presenting their case before the arbitrator. The award shall be made by the arbitrator. During the period in which the industrial dispute has been so referred, the government can prohibit the strike or lockout in connection with such dispute. That is discussed under Section 10 A subclause 4. Now, it may be noted that an award so passed by the arbitrator can be challenged before the court under Article 226 and 227 of the Indian Constitution, and that was held in Gujarat Steel Tubes Limited versus Mazdoor Sabha. So once again, the award for a voluntary reference, Section 10A, the award in that proceeding can be challenged under Article 226 and 227 of the Indian Constitution, and this was held in Gujarat Steel Tubes Limited versus Mazdoor Sabha 1980. Then in Rohtak Industries versus Rohtak Industries Union, Rohtak Industries versus Rohtak Industries Union 1976, the court pointed out that the remedy available to an employer on account of an illegal strike can be exercised through an arbitration award and has to be sought under the provisions relating to the penalties for such a strike. Now, difference between Section 10 and Section 10A. So here we discuss about we have mainly 4 differences. The first one, under Section 10, appropriate government is the competent authority to refer the dispute, whereas under Section 10A capital A, parties are competent to refer the dispute. Now the second one, under Section 10, no time limit is prescribed, whereas under Section 10 capital A, it must be referred after the arbitration agreement was signed. Third one, Section 10 capital A has to be invoked before Section 10 is invoked. And the fourth difference is that the power conferred under Section 10 is an administrative act, whereas the power conferred under Section 10 capital A is a quasi-judicial act. The arbitration is a quasi-judicial act. So that is with the end of this session. So we were discussing about the reference of industrial dispute by the government and by the parties. So thank you for listening. Thank you for your support. Like, comment and subscribe. Click that bell icon so that you get a notification when I upload my next video or a podcast. Have a nice day.